sorry, the rearrangement of chairs takes a little time. We are in the hands of our ushers.
Yes. But I was taking your lordship's note through the act, and from my lord, the Chief Justice, my lord, it rightly fell. This is an act of licensing era where there was too much of red tapeism, etc., etc. Now the country has progressed. But before I complete that act, my lord, I reached up to section 11. And I am going to show only 5 or 6 other sections, my lord, not the entire act. My lord, I would wish, my lord, subject to your lordship's approval, to show, my lord, why this act is still relevant and why it is kept. My lord, 1991 is the year in which, my lord, we shifted as a nation from, my lord, old licensing regime to free economy regime. No, that, my lord, I have given in volume 4G at page 385. Only few paragraphs, my lord. This was when, just, my lord, by way of information, Narasimha Rao ji was the Prime Minister and Dr. Manmohan Singh was the Finance Minister. They pioneered, my lord, this new industrial policy. Lord, please come to para 7. I'll read only relevant part, my lord. Page 385, my lord.
Which volume 3?
4G.
4G.
Roman 4, capital G.
Is there a E?
Why this act is still relevant? Why it is consciously not either amended or repealed? And why it would be necessary, my lord, for your lordships to examine it in that context, that in future, even present, it is implemented and it needs to be implemented, maybe, my lord, depending upon the circumstances. But para 3 to 6, earlier policies are dealt with. I am not, my lord, taking your lordships. Para 7 of, my lord, this is industrial policy dated July 1991. Para 7, the policies created a climate for rapid industrial growth in the country. That is earlier policies. Thus, on the eve of the 7th 5-year plan, a broad-based infrastructure had been built up. Basic industries had been established. A high degree of self-reliance in a large number of items, raw materials, intermediates, finished goods had been achieved. New growth centers of industrial activity has emerged and has new generation of entrepreneurs. A large number of engineers, technicians, and skilled workers had also been trained. Now, my lord, kindly, my lord, see the next page. But it demarcates in 4 categories, my lord. In para 19, my lord. In pursuit of the above objective, the government has decided to take a series of initiatives in respect of policies relating to the following areas: industrial licensing, foreign investment, foreign technology agreements, public sector policy, MRTPA. My lord, we are concerned with the first only, my lord. Please see, my lord, industrial licensing policy. Industrial licensing policy, licensing is governed by the Industries Development and Regulation Act 1951. The Industrial Policy Resolution of 1956 identified the following 3 categories of industries: those that would be reserved for development in public sector, those that would be permitted for development through private enterprise with or without state participation, and those in which investment initiatives would ordinarily emanate from private entrepreneurs. Over the years, keeping in view the changing industrial score seen in the country, the policy has undergone modifications. Industrial licensing policy and procedures have also been liberalized from time to time. A full realization of the industrial potential of the country calls for continuation of the process of change. Para 22 thereafter, your lordships may skip 21. The winds of change have been with us for some time. The industrial licensing system has been gradually moving away from concept of capacity licensing. The system of reservation for public sector undertaking has been evolving towards an ethos of greater flexibility, and private sector enterprise had been gradually allowed to enter into many of these areas uh, of a case of caste basis. Sorry, no. On case-to-case basis. Further, impetus must be provided to these changes, which alone can push this country towards the attainment of its entrepreneurial and industrial potential. This called for bold and imaginative decisions designed to remove restraints on capacity creation, while at the same time ensuring the overriding national interests are not jeopardized. Thereafter, your lordships may kindly come to Lord para 39, my lord, page 389. But I'm skipping what is not relevant for the IRDA purpose, because they made several changes in foreign direct investment, etc., etc. And MRTP Act was, my lord, mark one thing, MRTP Act was substantially amended to bring it in tune with the new regime of liberalization. Why I say this, the government thereafter consciously neither repealed the IDRA nor amended IDRA. And I'll point out, my lord, why.
But Solicitor, you are relying upon this 1991 today. So it looks very primitive. And so much has changed now. Today, you are relying upon 91 policy.
I'm not relying upon. I'm sorry. I'm not relying upon.
Right.
I am. This can't be relied
To
upon.
respond to what Honorable Chief Justice of India said, I mean, this policy in today's context.
Kindly allow me.
Right.
I am not justifying the act based on this policy. It's a 91 policy, years back. My purpose is to show that the changes, winds of change, as they say, is taken note of. There are certain changes made. The IRDA is taken note of. Well, this is the policy which de-licensed everything, except some items. I am not saying that I justify IRDA. I'm not supposed to justify, because that's not under challenge, but that's a very basic argument. I'm just saying that this was, my lord, a event which changed the course of our economic history. But still, IRDA was neither amended nor repealed. And, my lord, at the end of this, my lord, I'll be able to show why I am showing this, my lord. Not to rely upon it, to justify existence of IRDA, to point out to your lordships that it is still in operation, and in future it can still be required to be utilized by the country, and therefore consciously it was not done. As my lord, the Chief Justice of India, my lord, was pleased to say that now we are in a de-licensed era. That is true. From 91, we are in a de-licensed era. And the provisions which I read provided for licensing. But some scheduled industries are still under licensing regime. And I will be able to show in future, if the circumstances or contingencies so demand, the country may need again to control them. And I will give the illustrations. Lord, para 39, decisions of the government. Lord, kindly see A, industrial licensing policy. Industrial licensing will be abolished for all projects except for a short list of industries related to security and strategic concerns, social reasons, hazardous chemicals, and overriding environmental reasons, and items of elitist consumption, that is list at Annexure 2. Your lordships need not go it right now, because that also has kept on being amended. I'll point out what remains in the schedule as on date, my lords. Now, your lordships, my lord, kindly turn to Annexure 2, my lord, just to have a flavor, my lord. 392, my lord. Since, my lord, this case incidentally concerns alcohol, but as I have pointed out, my effort, my lord, is not Lord, let me, my lord, make this again clear. Lord, my effort is not to succeed in case of alcohol. That alcohol only center has the power under entry 52. Lord, entry 52 encompasses several things. And therefore, my lord, your lordships in this combination are examining the question of law. Therefore, my lord, must point out from a broader perspective than just alcohol, because that happens to be the case here, the fact situation, but your lordship's law would apply across all industries. Lord, distillation and brewing of alcohol was still under the licensing regime. Now it is not, my lord, I must say, but it was, my lord, at the relevant point of time. Now your lordships may kindly see what is the present position. List annexure 2 constantly became shrinking. It remains shrinking, my lord, more and
Where
more.
will we get the latest position, Solicitor?
Yes, my lord, we have uploaded it, but it has not reached your lordships.
Okay.
My lord, it's only one page.
It will not be in this act.
It's not in this act. My lord, it's one page, my lord, if I can request.
Yes, certainly.
4I. 4I, page 23. Now the act, my lord, controls, regulates, or provides for licensing of these products. As on date.
4I.
Lord, for my lord, only completing the record, section 29 capital B of IDRA provides or empowers the central government to exempt certain industries. Your lordship did not go into
29B.
29 capital B, under which, my lord, several industries were, my lord, removed from list schedule 2.
Oh, I see.
The effect of 29B is it remains in the schedule to the act, meaning thereby it can always be brought under regulation. But for the time being, it would be exempted from the provisions or the regime or the licensing policies, etc., under the IDRA. So potential regulation remains. So, your lordships have not page 23. I'm sorry. It would be here, my lord. My apologies, my lord. It would be displayed, my lord.
Yeah, we got it. It's now there's a press note number 3.
Yes, 3, my lord. The press note number 17 series regarding environmental clearance of industrial license conditions of letter of intent industrial license relates to pre-1991 period. After the Industrial Policy Resolution 91 and considering various amendments made to notification number so and so, only the following 4 industries are covered under the compulsory licenses: cigars and cigarettes of tobacco and manufactured tobacco substitutes, electronic, aerospace and defense equipment, industrial explosives, and hazardous chemicals. These are, Lord, now under licensing regime. The entire act applies to them. The rest of the industries are, as on date, out of it. But kindly bear one factor in mind. 91 policy delicensed everything. Thereafter, my lord, except for the rest of the industries were exempted from the licensing regime. But they continued in the schedule very consciously.
Schedule is not amended.
Not amended. MRTP Act, my lord, there is a discussion, my lord, in 1991 policy itself, that now we will have to bring it in tune with this liberalized regime. We also amend the MRTP Act, but this act is not even amended. And there is a reason why.
You are trying to say that following the liberalization regime that we entered into from the licensed Raj, the government of India is consciously taking certain steps. And the press note that you are pointing out is that only now these 4 categories of industries are within the licensed Raj.
Correct.
But we are keeping the industries mentioned in the schedule to the Act, so that at a given moment, if we have to do something,
Correct.
we'll bring them within. But then the context, if you look at also 20B, which is the empowering, there also you have to do it on the exigencies or the contingencies that are mentioned in 29B.
No, my lord, kindly, I also, my lord, your lordships are right. My lord, I also initially read it like it, and that may be a correct reading, but thereafter, my lord, I changed my interpretation. My lord, that is only for one category. Please,
Yes.
my lord, read 29B.
Yes.
If the central government is of the opinion, having regard to the smallness of the number of workers employed, or to the amount invested in any industrial undertaking, or to the desirability of encouraging small undertakings generally. Well, this is first part.
Yes.
Or to the stage of development of any scheduled industry. This is second part, which applies to the first 3 contingencies are for small industries. For other scheduled industries, stage of development of the scheduled industry, that it would not be in public interest to apply all or any of the provisions of this act thereto, it may by notification in the official gazette exempt, subject to such conditions as it may think fit to impose, etc., etc. So, my lord, first 3 is for small industries. Rest is, for example, non-potable alcohol is still in the schedule. No, nobody disputes that fact.
It's not regulated by the Act.
It's not regulated by the Act. As it stands today, it's not regulated by the Act. So we have a particular quantity of non-potable alcohol which is produced. Now, non-potable alcohol has several uses. I'm just giving a hypothetical example why the Act still retains the power to regulate in future. It goes into making of the potable alcohol. It goes into making of certain medicinal preparations. It goes into making of certain paints and other industrial uses, my lord. Now, my lord, we had COVID, for example. And we required, and the government of India, the nation requires that entire quantity of industrial alcohol should be used only for manufacturing sanitizers, for example, giving a hypothetical example. Then the government can again utilize the regulatory power. Therefore, the power is retained. The regime of forbearance is enforced, that we will forbear from exercising. But the power is there, and not a decision not to exercise the power is also a decision. I have given 2 examples in my original note, my lord. If your lordships can come to 2D, my original note, just to, my lord, illustrate this point. Page 56 of my note, my lord, volume 4D, 2D, I'm sorry, my volume 2D. So these are the figures taken from the Niti Aayog roadmap. Well, Niti Aayog conducts that what is the requirement of the country qua each schedule industry, product of each schedule industry, whether that requirement is met. If not met, what steps are to be taken? Well, everything, well, since decades, everything happens very scientifically. Well, there is a system in place. The country, my lord, doesn't run on an ad hoc basis. There are systems, there are institutions, every institution functions, they have their own defined roles, etc. Please see, my lord, page 55 first. What is the position of alcohol? This is what the Niti Aayog would examine. Your Lordship have the chart, my lord? Just I am illustrating, my lord. This is by way of an illustration. My lord, 21-22, the ethanol requirement, my lord, for blending was 437 crores. I could have 50. My lord, page 55, 2D, volume 2D. For blending, requirement was 437 crores. And for other uses, that is potable, my lord, making beverages plus industrial alcohol, it was 270 crore liters. So the total requirement was 707. The country was meeting with that requirement, therefore regulation was not necessary. But suddenly, suppose there is a spike in the use of alcohol, not potable alcohol, but for use of any other alcohol, then possibly, my lord, the central government can step in and say that now we will control what will be produced, license will have to be required, from where you will procure the raw material. The raw material also may be required to be diverted. That sugar cane becomes molasses and molasses becomes ultimately the alcohol. So sugar cane would not be diverted for manufacturing sugar. It should be used for only manufacturing alcohol in a given set of circumstances. Therefore, the law is live. Right now exempting most of the items. My lord, similarly, my lord, please come to the next page, my lord. My lord, this is regarding the sugar. The sugar is an essential element, as essential food item, my lord. Please see, my lord, sugar cane production vis-a-vis sugar production and sugar consumption. So kindly, my lord, have a look at page 56. Lord, sugar cane production is this is in lakhs metric ton. In 1819, sugar cane production is 4054. Now, sugar is produced is 332 metric ton, lakhs metric ton, and the consumption is less than this. Now, suppose, my lord, for whatever reasons, international reasons or national reasons or whatever reasons, there is sudden decrease in the sugar production, and the nation needs uniform availability of sugar at uniform prices, then, my lord, sugar remains in the schedule, right now under the forbearance regime. This can be true, my lord, about every product. Just to give an example, my lord, in case of, my lord, say defense industry, one of the scheduled industries. So suddenly the defense equipments manufacturing demand rises for any international reason, my lord. There may be some minerals which are which go into the manufacturing of the explosive or something. I'm giving a very, very broad and hypothetical example. Then the government can step in. Right now, you do without licensing, free market, free economy, no licensing. You do whatever you want to do. You invest your money, let the country grow, let the economy grow. But in certain circumstances, you have to step in. That is.
Then in regard to industrial alcohol, is the government exercising its regulatory power?
Yes.
Today, the compulsory licensing for industrial alcohol is gone. All alcohol is gone.
There are some regulatory controls. Licensing is not required, but I will show, there are some regulatory controls. The reason is this. Reason is
fair enough. Now you were actually last time when we stopped, you were looking at our the statutory provisions. So you showed us section 10.
Before that, my lord, would your lordship,
let's quickly run through the statutory provisions so we can make some headway then.
And my lord, I'll show, my lord, what. Lord, there is a biofuel policy, and ethanol is an element in the biofuel policy. It's a national project. Well, and if that project succeeds, my lord, the dependence on other fuel would be substantially reduced. So, my lord, there is some kind of a regulation in national interest, my lord. Now, please see, my lord, the My lord, I'll take your lordships, my lord, to the notif, it's there, part of my written original written submissions, my lord. But, my lord, before, as my lords have, my lord, been pleased to say, my lord, I'll just take your lordships to the act. Lordship, may give me only a minute, my lords. Your lordship, I was at section 11. I'll read only those sections which are relevant, my lord. My lord, first, kindly see section 10. And bear, my lord, one fact in mind, your lordships are not deciding only alcohol. That incidentally happens to be the fact of a case which is referred. This law which my lords in this 9-judge combination would lay down, will apply to all scheduled industries today and in future also if regulation is required. Therefore, my lord, I am assisting not, my lord, to win in an alcohol-related matter, to assist your lordships fully, objectively. Lord, section 10(3), subsection 3. Where an industrial undertaking is registered under this section, there shall be issued to the owner of the undertaking of or the central government, as the case may be, a certificate of registration containing the productive capacity. Well, production comes here. That's the reason I am not showing. Productive capacity of the industrial undertaking and such other particulars. Lord, 4 last 2 lines also. Productive capacity of the industrial undertaking and other prescribed particulars. Lord, suppose some commodity from the scheduled industry is now brought under licensing regime for some good reason, my lord, subject to your lordship's judicial review if challenged. Then, my lord, this will be done. Then 5, in specifying the productive capacity in any certificate of registration issued under subsection 3, the central government shall take into consideration the productive or installed capacity of the industrial undertaking as specified in the application for registration made under subsection 1, the level of production immediately before the date on which the application for registration was made under subsection 1, the level of highest annual production during the 3 years immediately, etc., etc. So, production is a part of IRDA.
Yes.
Which undisputably traces its origin to entry 52, list 1, read with entry 33, list 3. Lord, why I say this? Tikaramji says industry in 52 is confined only to manufacturing. After taking note of the act itself, my lord, I'll show, my lord, how Tikaramji is either bad or is obiter.
Now, apart from 10.3 and 10.5, what is the other provision?
My lord, 11.2. My lord, I have marked my copy, my lord, I will not read anything which is irrelevant.
Right.
11.2. A license or permission under subsection 1 may contain such conditions, including in particular conditions as to the location of the undertaking and the minimum standards in respect of size to be provided therein, as the central government may deem fit to impose in accordance with rules. In future, this contingency might arise with regard to some of the scheduled industries. Therefore, this provision. Then 11A, your lordships have seen license for producing or manufacturing new articles. But please see, my lord, 11B, power of central government to specify, my lord, I'm sorry, my lord, one more fact. While going through this, my lord, kindly bear one fact in mind, because that would be necessary when I assist your lordships on the question of repugnancy between the state provision and the central provision. Lord, one of the condition, one of the ground on which your lordship would test repugnancy would be that is the central act intending to cover the entire field of the subject? If the entire field is occupied by the central law, that would be one of the considerations. My lord, the Chief Justice in forum has, my lord, analyzed that. And my lord, I'll cite that judgment and 1 or 2 judgment on that. So that is one more reason why your lordships may see this act in totality, that it occupies it intends to occupy the entire field. They may use it, they may not use it. Then 11B, power of the central government to specify the requirements which shall be complied with by small-scale industries, industrial undertakings. My lord, this is what my lord Justice Roy, my lord, was my lord, saying 29B. Small industries those three conditions. Rest, A, promoting in a harmonious manner the industrial economy of the country and easing the problem of unemployment. Then B, securing that the ownership and control of material resources of the community are so distributed as best to subserve the common good. My lord, in some contingency in future, like COVID, this power may have to be invoked. That includes, my lord, control over the raw material also, because that's one of the natural resource or natural, my lord, ownership of the nation as a whole. I may be, my lord, producing, but ultimately it has to be harmoniously and uniformly distributed for the advantage of everyone. Then, my lord, kindly see subsection 2D. The nature, it covers every, I'm sorry.
Yes, sir.
It covers every aspect of industry. 2D, 11B, subsection 2, subclause D. The nature, cost, and quality of the product of the industrial undertaking. This is also controlled.
This is in regard to small scale industry.
Yes, ma'am. I'm just saying that
All right, what apart from this, what else?
my lord, 13D. Further provision for licensing of industrial undertaking in special cases, effect any substantial expansion of an industrial undertaking which has been registered, etc. My lord, please see the explanation. Substantial explanation. Substantial expansion means the expansion of an existing industrial undertaking which substantially increases the productive capacity of the undertaking, or which is of such a nature as to amount virtually to a new industrial undertaking, but does not include any such expansion as in normal undertaking having regard to its nature, etc. The government in a fact situation can say, expand your industry, expand your manufacturing capacity. The way we did in oxygen. Now, my lord, 15. This is, my lord, again to show that the entire spectrum of every part of industrial activity is occupied by the central law, which is completely missed by Tikaramji judgment. Power to cause investigation to be made into scheduled industries or industrial undertakings, where the central government is of the opinion that A1, there has been or likely to be substantial fall in the volume of production in respect of any article or class of articles relatable to that industry. So please, not just the product. When I say sugar, sugar cane, which is the raw material, is also relatable to the industry. Production in respect of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking or undertakings, as the case may be, for which, having regard to the economic conditions prevailing, there is no justification. But the government can invoke 15 and say that why suddenly sugar production has gone down? Why suddenly non-potable alcohol production has gone down? Because it is necessary considering the economic condition of that.
Which are the other provisions? Let's quickly run through them.
I'm sorry, my lord. But I'll not take your lordship to anything irrelevant which is not read. I'll read.
Yes, sir.
2. There has been or is likely to be marked a deterioration in the quality of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking or undertaking, as the case may be. Then 3. There has been or is likely to be a rise in prices of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking or undertakings, as the case may be. And 4, it is necessary to take any such action as is provided in this chapter for the purpose of conserving any resources of national importance which are utilized in the industry or the industrial undertaking or undertakings, as the case may be. Then, my lords, may kindly come to 16. For powers of the central government on completion of investigation. Then A, power is to regulate the production of any article or class of articles by the industrial undertaking or undertakings and fixing the standard of production. Then C, B I am skipping, C, prohibiting the industrial undertaking or undertakings from resorting to any act or practice which might reduce its or their production capacity or economic value. Well, suppose we need industrial alcohol for sanitizer and majority of the industrial alcohol goes for manufacturing of potable intoxicating liquor. But the government can step in and say that circumstances exist that we give up our forbearance, we step in and we exercise this power. Controlling the prices or regulating the distribution of any article or class of articles which have been the subject matter of investigation. My lord, now price control is, my lord, your lordship may mark entry 34, list 3. Then your lordships have, my lord, seen 18 my lord, several provisions. I am not, I don't intend to read them, my lord. Please come to 18G. This is the only provision which is considered. Page 577, my lord, your lordship would take, of volume 4. Your lordships have that? May I read?
Yeah.
Power to control supply, distribution, price, etc. of certain articles. The central government, so far as it appears to it to be necessary or expedient, for securing equitable distribution and availability at fair prices. This is the condition. Which condition may arise in future even with regard to scheduled industries which are today exempted. Please go further, my lord, at fair prices or any article or class of articles relatable to any scheduled industry. But the relatable means raw material also. The only condition is that it should be formation of an opinion that it is required for securing a equitable distribution and availability at the fair prices at a national level. So not only the production, the price, the quality, the manufacturing activity, but even related products also can be regulated. Lord, scheduled industry may, notwithstanding anything contained in any other provisions of this act, by notified order. Lord, this is one contention which I'll separately deal with, my lord, in a very short span. Notified order provide for regulating the supply and distribution thereof and trade and commerce therein. My lord, the expressions under 33, list 3, 33. Then, without prejudice to the generality of the powers conferred by subsection 1, a notified order made thereunder may provide A, for controlling the prices at which any such article or class thereof may be bought or sold. Price control. Then, my lord, C, prohibiting the withholding from sale of any such article or class thereof ordinarily kept for sale. Then D, And D is relevant, my lord, even for the purpose of answering that notified order question, my lord. For requiring any person manufacturing, producing, or holding in stock any such article or class thereof to sell the whole or part of the article so manufactured or produced during a specified period. So notified order can be for a specified period also. The power before that date and after that specified date still remains. Or to sell the whole or a part of the article so held in stock to such person or class of persons and in such circumstances as may be specified in the order. Then E, for regulating or prohibiting any class of commercial or financial transactions. See the width of the act, my lord. It occupies the field totally. Or for regulating or prohibiting any class of commercial or financial transactions relating to such article or class thereof, which in the opinion of the authority making the order are, or if unregulated, are likely to be detrimental to public interest. Even this can be done if public interest requires. It would normally not be done. That is forbearance. When it is done by way of a notified order. But the power remains.
But the impact of the forbearance, really, that's the point which you will have to meet, which is that today, except for 4 industries, cigarettes, electronic aerospace, industrial explosives, and hazardous chemicals, all other industries have been exempt from the provisions of the statute. The
This
power under section 29B has been utilized, you said. So, though theoretically speaking, the government, of course, the authority which issues an exemption can withdraw it. There's nothing to prevent the government from again withdrawing the exemption for 1 or more industries. Today, as the position stands, industrial alcohol per se stands exempted from the provisions of the Act, right? Now, in a theoretical future, the government can, of course, withdraw the exemption if it sees, as you rightly said, suppose, there's a COVID-like situation arose, and hopefully we hope it will never again arise.
Yes, anywhere in the world. Yes.
Anywhere in the world. But as you said that, you required sanitizers, therefore you had to control the production of alcohol used for sanitizers. Fair enough. But if the government has, as of a given point of time, exempted an industry completely from the operation of the Act, right? So as to obviate any exercise of the power under section 18G at that time, then other states
Or other provisions.
right,
Or
other states then denuded of the power to regulate that industry.
I'll, my lord. I'll just point out, my lord.
The exemption from the provisions of the statute covers everything or only licensing?
Only licensing, not section 2. Section 2, which is a declaration under entry 52. I just read, your lordship need not open. Section 2 of the IDRA, declaration as to expediency of control by union. It is hereby declared that it is expedient in public interest that union should take under its control the industries specified in the first schedule. This is not exempted. This operates. The regime of licensing is under the forbearance. But otherwise, what happens? And whether, my lord, I'm posing a question to myself, your lordships would interpret it in that manner that this is the result. What happens if your lordships were to say that so long as there is a notified order, the state would be denuded of its powers? If there is no notified order and we are in a forbearance, we means the central government is in a forbearance regime, they would have the power. My lord, the question I'm posing to myself is, my lord, can that be the jurisdictional ping pong? That if I interfere, they may have a law that would stop from operating because now there is a notified order. The moment I withdraw that notified order, they again either bring new law or their earlier law becomes operative. But that's not the intention. Therefore, my lord, my lord, at the outset said that what is relevant is, does this act occupy or intends to occupy entire field or not? It occupies, my lord, right from raw material, pricing, quality, production, lack of production, investigation, manufacturing, final goods, finished products, sale. Everything is, my lord, occupied. And once there is a law, my lord, there is a judgment which says that even a non-operative law, if it occupies the field and if it's a central law, the state government is denuded. My lord, that I'll read that judgment, my lord. What happened was that, my lord, in that judgment, I'll come to that, my lord, a little later. My lord, the question was, the central government brought a law. The parliament made a law. It gave assent, it was assented to by the President of India.
Yes.
The law provided that it shall come into force from such date as the central government may appoint. Every law provides. That was not done. And there was a state law, and the argument on behalf of the state was that since the law made by parliament is not brought into force, there is no question of repugnancy. Repugnancy with what? This court rejected that argument, saying that what Article 254 contemplates is law made by the parliament, not law in force. If there is a law made by the parliament and if the field is occupied, then the state is denuded. But I'll come to that judgment, madam.
But you have to answer this question of the other side, that entry 8 is outside, entry 8 list 2 is outside the scope of entry 24 of list 2.
That's a separate, my lord. Yes, I will have to answer that. I will, my lord, I'll immediately after that, my lord, I'll come on that. I'm just, my lord, trying to show that the Central Act occupies the field and intends to occupy the field, because that
From 18G?
22. So there is a development council contemplated, my lord, which
Okay, that's a direction to the development council. nothing major.
no, yes, my lord, please see 25, my lord. 26. Power to issue directions. The central government may give directions to any state government as to carrying into execution in the state of any of the provisions of this act. But completely supervening legislation. And last, your lordships may see, right. 31 also, I must show your lordship fully. Application of other laws not barred. The provisions of this act shall be in addition to and not save as otherwise expressly provided in this act in derogation of any other central act for the time being in force. The state act is barred. When I read the judgments on repugnancy, and there are only 3 judgments which I'll read, so this would be relevant. When I'll be able, my lord, I would attempt to satisfy your lordships that there is a legislative intent to occupy the field fully and completely. Now, your lordships, my lord, only see as a last, my lord, point on IRDA. Lord, very quickly, Please come to, my lord. I'll complete this within 10 minutes. The history of, my lord, this act, my lord, how alcohol is dealt with, my lord. That is at page 56 of my written submissions, my lord, 2D, volume 2D. I'll read only the my lord, title, not read, my lord, the whole thing. Because, my lord, the Chief Justice's question whether alcohol is right now under regulated category or not, my lord, some part of it is therefore. The second purpose of showing the history is
D. Written service.
56 of my written submissions, my lord. Volume 2D, 2 capital D, D for Delhi. The purpose is, my lord, it has always remained with the center, historically. My lord, Indian Power Alcohol Act used to govern 1948. Then comes, my lord, Indian Power Alcohol Amendment. I'm sorry, my lord. But Indian Power Alcohol Act used to govern, page 56. My lord. Then 57, Indian Power Alcohol Amendment Act came into force. Then central government constituted alcohol committee in 1956. Then, my lord, this order came to be passed, my lord, under 18G of IDRA, ethyl alcohol price control order. Your lordships need not read it, my lord. Then your lordships may kindly come to 69, National Biofuel Policy 2018. Lord, this is a very, very ambitious policy. And since we have the problems with fuel because it has its international implications, we are dependent upon some circumstances, my lord, in other countries, etc. So our country is, my lord, kind of trying, my lord, whether there is any alternative is available. The central government notified National Biofuel Policy on 4th June 2018 in the Gazette after it was approved by the Cabinet on 16th May 2018 with a view to promote biofuels in the country through structured program like ethanol blended petrol program, National Biodiesel Mission, Biodiesel Blending Program. The Niti Aayog in its report dated 2nd of June 21, Roadmap for Ethanol Blending in India 2020-25 made several recommendations to ensure uniform availability at a national level. Therefore, it can be done at state level of ethanol blends in the country. During the outbreak of COVID-19 pandemic, several orders were issued to ensure availability of ethanol at the notified price for the manufacture of sanitizers. In its product publication, Ministry of Petroleum and Natural Gas named Ethanol Growth Story has traced the evolution of the use of ethanol and its significance. The government has decided to advance the target of 20% ethanol blending in petrol by 5 years from 2030 to 2025. This necessarily needs control, central government regulation, pan-India implementation. My lord, there may be some notified order which may come with regard to, my lord, there may be, I'm not, my lord, predicting anything. My lord, therefore, my lord, the law still is relevant. That's all, my lord, my objective. As on 30th of November 2023, the ethanol production capacity in the country is about 1380 crore liters, out of which about 874 crore liters is molasses based and about 504 crore liters is grain based. The government of India has been implementing ethanol blended with petrol program throughout the country, wherein oil marketing companies sell petrol blended with ethanol. Under EBP program, government has fixed the target of 20% blending of ethanol with petrol by 2025. Further, with a view to enhance the ethanol production capacity in the country to achieve the blending targets set under EBP program, the government has notified various ethanol interest subvention schemes from July 2018 to April 2022. Under this scheme, that is National Biofuel Policy, the government is facilitating entrepreneurs to set up new distilleries, molasses-based, grain-based, and dual feed-based, on or expansion of existing distilleries, same Lord, throughout the country. Interest subvention at 6% per annum or 50% of rate of interest charged by banks or financial institution, whichever is lower, on the loans to be extended by banks and financial institutions is being borne by the central government for 5 years, including 1 year moratorium. This would at some stage need regulation to ensure sufficient quantity of ethanol. But now we are encouraging that we will bear some kind of some portion of interest. There would be a moratorium, invest in this industry, produce more ethanol, let the ethanol be available for the purpose of blending with petrol rather than using it for any other purpose, etc. At some stage, look, this is may not this is on. Look, this may not directly assist your lordships on answering the questions. Look, this is only apropos. My lords, my lord, very right observation that after 91 liberalization, would this act stand the scrutiny? To which, my lord, my answer was that that's not in question, but relevant, my lord, submission is that this still is in force for a good reason, for a valid reason. And there are situations and circumstances which we may not be able to contemplate now, but which may be required to be, my lord, exercised for the purpose of regulation. That's, my lord, the purpose, my lord. Can I, in 5 minutes, show, my lord, the history of IRDA and switch over, my lord, to the next point?
See, actually, once we Just to sort of summarize what you have, what you have said up to now. One, the expression intoxicating drinks in entry 8 of list 2 covers essentially what is called potable alcohol.
Beverages, yes,
Beverages meant for human consumption.
which has the effect of intoxication.
Right. Now, if that is so, denatured spirit, or what we loosely call industrial alcohol, we'll call it denatured spirit, is not within the ambit of entry 8 of list 2. 2. If denatured spirit is not within the ambit of entry 8 of list 2, this is not what you said, but I'm just putting it. It would otherwise have been within the fold of entry 24 of list 2.
That is true.
Right?
I am
One
also,
second,
yes.
just one second. It would have been within the ambit of entry 24 of list 2, which is the provision relating to industries. 3.
Corresponding to
entry
52.
3. Entry 24 of list 2 is subject to entry 52 of list 1. 4. Parliament has enacted a law within in the legislative domain falling under entry 52 of list 1, which specifically covers non-potable alcohol.
Only.
5. Once Parliament has made a declaration under section 50, under entry 52, and has enacted a law, that law covers the entire field. Entry 52 of 6th, entry 52 of list 1, nonetheless, leaves open an area under entry 33 of list 3. But here again, the Industries Development Regulation Act covers the entire field, even in relation to entry 33 of list 3. And to that extent, therefore, their states are denuded, both by virtue, their states are denuded for 2 reasons. 1, denatured spirit, all spirit other than potable liquor falls within the ambit of entry 52 of list 1. 2, in regard to entry 33 of list 3, Parliament having made a comprehensive legislation on the subject, that covers the field and therefore the states are ousted. I think that's your
I could not have put
these
it
are the
more
6
succinctly than this.
propositions, which I think.
But only one thing which occurred to us, my lord, after my arguments.
So says brother, sister Nagaratna also says that Article 246(3) makes it very clear that every exercise of power by the state legislature under the state list or under the concurrent list is subject to list 1 is subject to list 1 and list 3 exercise of power by the Parliament.
So otherwise also denuded. Lord, one more thing, my lord, just.
Now I think we can go ahead because we'll like to hear them and rejoin. And now you've made your point.
No, my lord,
I can quickly in rapid fire take us through the rest
only
of your
one thing, my lord, and my lord,
the judgments you can cite.
Yes, my lord. But one thing, my lord. I was just wondering, my lord, in 84 list 1, the word expression used is alcoholic liquor for human consumption. Why it is, my lord? I have already, my lord, argued that 84 is a taxing entry. So please come to page 32.
Now, have you finished this part about the your history of the regulation of alcohol? You want us to see those headings?
One or
Just
two.
one or two, just show us so that part is over. Then we don't have to come back to it.
Page 61.
Not very strictly relevant, but you can just show it to us so that we'll see the headings. We are rightly only referring to the headings.
Lord, Indian Power Alcohol Act also had a declaration like this, 52. That's all, Lord. Your Lordships need not read it. I have, my Lord, reproduced. My Lord, I have also reproduced, my Lord, whenever there is an amendment made in the IDRA, the statement of objection reasons, and that has remained consistent, my Lord, that is pan-India, uniformity, fair prices. My Lord, that is, my Lord, at your Lordships would find page 62. It was amended in 53, my Lord, where 18G, my Lord, came in that amendment, my Lord. My Lord, thereafter, your Lordships can, my Lord, come to page, my Lord, 64. We introduced the central government, or rather the Parliament, introduced, my Lord, fermentation industries as a heading as item number 26 in the schedule to IDRA. Correct, my lords? I have given, my lord, the statement of objection.
The solicitor, who was the junior who assisted you the most in preparing these propositions?
My lord, all four of us used to sit together for.
But we are going to, at the end, after you finish your argument, we are going to ask your junior to make a 5-minute argument before us. We want them to have the benefit of arguing before 9 judges.
I
So
have,
5 minutes, but
I
you
have
have-
requested at the outset, but it's a rare opportunity. They really work very hard.
I
They
just
know
want
the
to put them
subject
on
better
notice
than
so
me.
that- I want to put them on notice so that they are not taken by surprise, that we are going to call upon them, maybe for 2 minutes, just to make
No,
a
my lord,
point.
5 to 7 minutes, my lord, they are fully
We'll
prepared.
make a last minute.
And they are prepared better than me, my lord.
Also call upon only one of them, so we might do that as well.
My
So,
lord,
you know,
that
it's going
may
to
be difficult for me, my lord, or your lordship to choose. My lord,
So teach to all the juniors to make a point which has not been made by the solicitor.
My lord.
And
my lord, I could not do what your lordships did in 5 minutes. I took 1.5 days.
no.
My lord, they can't do it in 2 minutes.
We-
Let it be 5 seconds.
Our was distillation of the alcohol after you had given us the raw material. See. All right, now what else now? Just let's go quickly now.
Kindly come to, my lord, page 67. And this is relevant, my lord. Therefore, my lord, I must show this. 67. And this was not shown. My lord. Your lordships must have. Lord, judgment in Bihar distillery comes, my lord, authored by, incidentally, nothing, Justice B.P. Jeevan Reddy. Lord, in 98, Justice Reddy becomes chairman of the Law Commission. And the judgment is, my lord, taken up as a suo moto, a recommendation to the government.
For that, yes.
Yes, ma'am. And the government, my lord, in the parliament, not government, parliament only accepts the recommendation partly. And this is the stage in, my lord, page 68, where the amendment comes in entry 26 of the IDRA. Lord, page 68, there is an amendment in the act made by the parliament, 14th May 2016. My lord, I have given you, if your lordships may read it. My lord, I would earnestly, my lord, request your lordships to read it. Right now, I am not taking your lordships' time, but that would, my lord, reflect the legislative intent that we don't wish to give up the control on non-potable alcohol. So therefore, my lord, what they do was, they only amend the entry, and the entry, my lord, which reads as on now, comes. And that entry is, my lord, as your lordships have already seen, fermentation industries within bracket other than potable alcohol. So potable is consciously kept, my lord, as a part of the schedule to IDR. And there is a detailed, my lord, statement of objection reasons, which, my lord, I am not taking your lordships through. And last, my lord, even recently, Lord, 23, this act is amended. Just to show, my lord, that the act has not outlived its life. It is still existing. It's still alive. Whenever necessary, it is invoked. That's the only purpose, my lord. Now, your lordships, my lord, kindly come to Tikaram ji. My lord, unfortunately,
Actually, before we go to Tikaram ji, just see the statement of objection reasons of that 2016 amendment.
yes,
Just see para 5 at page 69 of your note.
yes, ma'am. Yes, page 69.
Para 4, they refer to the Law Commission 158 report.
Yeah,
Now
yeah,
just
yes.
see why Parliament did not accept it.
5, my lord. The recommendation of the Law Commission of India was examined in depth by the government. If the subject alcohol is taken out of the first schedule of the Act, both industrial alcohol and potable alcohol would come under the purview of the state government, which is not in consonance with the judgment of the Supreme Court. Moreover, the effect of the implementation of recommendation of the Law Commission would be that the subject alcohol, which covers both industrial alcohol and potable alcohol, would no longer be a central subject. Therefore, it is proposed to amend the first schedule to the Industrial Development and Regulation Act by substituting the heading 26 thereof as fermentation industries within bracket other than potable alcohol, so that it would be in conformity with judgment of the Supreme Court, and also ensure that industries engaged in manufacture of alcohol meant for potable purposes shall be under the total and exclusive control of states in all respects. That was, my lord, the judgment in Bihar distillery. The central government would continue to be responsible for formulating policy and regulating foreign collaboration, foreign direct investment, and foreign technology collaboration agreements for all products of fermentation industries, including industrial alcohol and potable alcohol. So this part of potable alcohol is also controlled, so far as foreign collaboration is concerned.
Yes. That's right. Yes.
My lord, I am not going to read, my lord, all the judgments, my lord. I'll read only few paragraphs, except Tikaramji. And there is a reason, my lord. Tikaramji also, my lord, I don't intend to read the whole, but some parts, my lord. The difficulty is, not only here, but earlier also, whenever Tikaramji was followed, only 2 or 3 paragraphs were cited out of context. Tikaramji is not what, my lord, the other side and subsequent judgment says is laid down. That's not what Tikaramji says. Lord, in Tikaramji, the dispute was this limited dispute. And, my lord, the 2 findings which are consistently being relied upon by subsequent benches and today by the petitioners are in fact obiter. It never fell for consideration, and therefore there is no discussion also. Now, please bear in mind what was the fact situation in Tikaramji. Lord, sugar, Lord, just Lord, on the slight Lord, deviation.
Which volume, please?
Volume 5, page 80. Sugar, somebody, my lord, told George Bernard Shaw that, do you know sugar is the only word in English where S is pronounced as SH? His answer was, are you sure? Sure is another word.
Right.
The sugar is doubtlessly, my lord, a scheduled industry. Sugar is a part of, my lord, IDR.
Yes.
There was a central act governing sugar.
Yes.
The state of UP came out with an act governing sugar cane, which was, my lord, the raw material.
Yes.
That was under challenge by some, my lord, affected parties, including Tikaramji, that the state act is repugnant to the central act. So the examination of the court in Tikaramji judgment was limited as to whether the state act governing sugarcane and the central act governing sugar have any repugnancy.
Yes.
And the only ratio decidendi is there is no repugnancy. Rest of the things, my lord, nobody argued, no, and court, my lord, though observes, but that never fell for consideration. So please come to, my lord, para 2. Para, my lord, first para, my lord, after Justice N.H. Bhagwati. These petitions under Article 32 impugn the validity of UP Sugarcane Regulation and Supply and Regulation of Supply and Purchase Act 1953. 2. The petitioners are sugarcane growers in several villages of district so-and-so in UP, numbering so-and-so in aggregate. The notification dated 27 September 54 issued in exercise of the powers conferred under subsection 1A, read with subsection 2B of section 16 of the Impugned Act ordered so-and-so, 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 my lord. Please now come to, my lord, straight. Para 8. Lord, it would be page 85. Lords. On 31st of October 1951, Parliament enacted the Industries Development and Regulation Act 1951 to provide for the development and regulation of certain industries. By Section 2 of the Act, it was declared that it was expedient in public interest that the Union should take under its control the industries specified in the first schedule, etc. My lord. Then, my lord, your lordships may, my lord, kindly turn to para 10.
Yes.
Act 65 of 51, my lord, that is IDRA.
Yes.
There is another act also, my lord, that is 10 of, that is Essential Commodities Act, my lord. I'll point out whenever there is a reference to, because the court refers to the act by act number, my lord. Therefore, there is a likelihood of some confusion. Lord, whenever the Honorable Court is being assisted with entries in the list or any constitutional provision, the minimum we are supposed to do is to show the history, the Constituent Assembly debates, etc. That's not shown. Only on that ground, my lord, I can respectfully urge that this is per inquiry. I have read, my lord, entry 52, how entry 33 came into picture. What is the history behind entry 24 list 2? Nothing, my lord. No argument, no discussion, my lord. Because there was no, my lord, possibly assistance on that. Page para 10, my lord. Act 65 of 1951 was amended by Act 26 of 53, which by adding chapter 13, 3B, my lord, that is 18G, my lord, your lordships can mark here, my lord, 18G. I'm sorry.
Yes.
Invested the central government inter alia with power so far as it appeared to it necessary or expedient for securing the equitable distribution as so and so. And 11. On 1/4/55, Parliament enacted Essential Commodities Act 1955, providing for so and so. This is Act number 10 of 55. That is Essential Commodities Act. Your lordships, my lord, kindly see para 12 now. In exercise of the powers conferred by Section 3 of the Act, that is Essential Commodities Act, the central government promulgated on 27th August 55 the Sugar Control Order 1955 and the Sugarcane Control Order 1955. Both were central orders, my lord. The latter empowered the central government, after consultation with such authorities, bodies, and or associations as it may deem fit by notification in the official gazette from time to time, to fix the price of sugarcane and direct payment thereof, and also to regulate the movement of sugarcane. The power to regulate the movement of sugarcane comprise the power to prohibit or restrict or otherwise regulate the export of sugarcane from any area for supply to different factories, and the power to direct that no gur, there is jaggery, or sugar shall be manufactured from sugarcane except under and in accordance with the conditions specified in a license issued in this behalf. Sugarcane was the raw material for sugar. Then, my lord, 14. Only one argument is relevant for the present purpose. Learned counsel for the petitioner urged before us that state of UP had no power to enact the impugned act, as the act is with respect to the subject of industries, the control of which by the union is declared by parliament by law to be expedient in public interest within the meaning of entry 52 list 1 and is therefore within the exclusive province of the parliament. The impugned act is therefore ultra vires the power of state legislature and is a colorable exercise of legislative power of the state. The impugned act is repugnant to, that is IDRA, and Act 10, that is Essential Commodities Act, and in the event of court holding that impugned act was within legislative competence of the state legislature, it is void by reason of repugnancy. Rest is, my lord, challenge under Article 14, 19, 1G, etc., with which we are not concerned. My lord, please see 15. This contention relates to the legislative competence of UP legislature to enact the impugned act, that is, my lord, Sugarcane, UP Sugarcane Act. It was contended that even though the impugned act purported to legislate in regard to sugarcane required for use in sugar factories, it was in pith and substance and in true nature and effect legislation in regard to sugar industry, which had been declared by Act 65 of 51, that is IDRA, to be an industry and the control of which the union was expedient in public interest and was therefore within the exclusive province of parliament under entry 52 list 1. The word industry, it was contended, was a word of wide import and included not only the process of manufacture or production, but also things which were necessary, incidental to it, that is raw materials. Because that was the fact situation. One state was dealing with sugarcane, center was dealing with sugar and sugarcane both. For the industry, as also the product of that industry and would therefore include within its connotation the production, supply, and distribution of raw materials for which for the industry, which meant sugar cane in relation to sugar industry. It was also contended that insofar as the impugned act purported to legislate in regard to sugar cane, which was necessary ingredient in production of sugar, it was colorable exercise, etc. Then, my lord, 16. It was contended on behalf of the state, on the other hand, that after the advent of war and the proclamation of emergency under 102 of Government of India Act and by so and so, your lordships may directly come to, my lord, the third constitutional amendment act amending entry 33 of list 3, the central legislature turn was operating all along on what became the effect of concurrent field even in regard to sugarcane, that the investing the central government with the power to legislate in the sphere of provincial list did not deprive the provincial legislature of such power, and that both the central legislature as well as state legislature had legislative competence to legislate in regard to these fields, which were for the purpose of legislative competence translated into concurrence field, and that therefore the UP state legislature was competent to enact the impugned act, which would be valid within its own sphere, except for repugnancy with any of the provisions of the central legislature covering the same field. So they say for sugar cane we are entitled. You go section by section, whatever is repugnant, the central law will prevail. Then, my lord, kindly come to 18. Production, supply, and distribution of goods was no doubt within the exclusive sphere of the state legislature, but it was subject to provisions of entry 33 of list 3, which gave concurrent powers of legislation to the union as well as the states in the manner of trade and commerce in and production, supply, and distribution of the products of industries, where the control of such industries by the union was declared by parliament to so and so, so and so. Then, my lord, somewhere there is no classitim. After entry 52 list 1, which was exclusive province of parliament, leaving other industries within entry 24 of list 2, which was the exclusive province of state. The products of industries which were comprised in entry 24 were dealt with by the state legislature, which had under entry 27 of that list power to legislate in regard to production, supply, and distribution of goods. Goods according to the definition contained in Article 366 of 366(12), including all raw materials, commodities, and articles. This is one of the findings. that raw material would not fall under 24 or 52, it would fall under 27 because it says goods. And according to Tikaram, goods means raw material. But 27 says subject to 33, which I'll show. When, however, it came to the products of the controlled industries comprised in entry 52 of list 1, trade and commerce in, and production, supply and distribution of these goods became the subject matter of entry 33 of list 3, and both parliament and the state legislature had jurisdiction to legislate in regard thereto. The amendment of entry 33 of list 3 by the Constitution 3rd Amendment Act only enlarged the scope of that entry without in any manner whatsoever detracting from the legislative competence of Parliament and the state legislature to legislate in regard to the same. Look, this, in my respectful submission, is wrong if we go by 27. Entry 27 says goods subject to 33. If the matters had stood there, the sugar industry being a controlled industry, legislation in regard to the same would have been in exclusive province of Parliament, and production, supply and distribution of product of sugar industry, that is sugar, as a finished product would have been within entry 33 list 3. Sugarcane would certainly not have been comprised within entry 33 of list 3, as it was not the product of sugar industry, which was a controlled industry. Kindly pause here for a minute. When we say control of industry, the term industry would include right from raw material till the finished products. But Supreme Court in Tikaramji throughout goes that no, raw material is outside. For final product, you have to rely on 33. And gave a restricted and contrived meaning to the term industry under list 1. Entry 52.
Under Article 366, Clause 12, the expression goods is defined.
Correct.
To mean it's an inclusive definition, includes all materials, commodities and articles.
Correct, my lord. But I will show, my lord, if the
That
way...
is a definition which is already given in the Constitution as to what goods refers to.
But, my lord, that doesn't come in the way of my submission for the simple reason that the term goods are used in entry 27.
And in entry.
Which is subject to 33, which is a concurrent subject, my lord. But definition clause is always unless the context otherwise.
It is not a restricted definition, it is an inclusive definition.
I'm not on goods, restricted definition of industry, my lord, which I'll come to. Entry 33 of list 2 by the Constitution 3rd Amendment Act that foodstuffs including edible oil seeds and oils came to be included within that list, and it was possible to legislate in regard to sugarcane having recourse to entry 33 of list 3, save for that sugarcane being goods fell directly within entry 27 list 2 and was within the exclusive jurisdiction of the state legislature. Production, supply and distribution of sugarcane being thus within exclusive sphere of the state legislature, the UP state legislature would be without anything more competent to legislate in regard to the same, and impugn act would be intra vires the state legislature. This is the argument. The argument, however, was that the word industry was a word of wide import and should be construed, my lord, kindly read, this is, my lord, considered to be the ratio. The argument, however, was that the word industry was a word of wide import and should be construed as including not only the process of manufacture or production, but also activities antecedent thereto, such as acquisition of raw materials, and subsequent thereto, such as disposal of finished products of that industry. My lord, I have shown to your lordships in IDRA that right from the raw material till finished products, everything is covered. Because it says articles, products relatable to the scheduled products.
Section 18G that you read to say.
And 15 also, 15 also.
Relatable and 15 also.
Also.
So by the word use of the word article relatable, you are saying that raw material would also come in with sugar, the final product, which is in the domain of the union.
idea. And Manoj, the Tikaramji ultimately says that industry would only mean only that manufacturing part. That's the finding, only manufacture. Manoj, now kindly see the Manoj, the difficulty.
Material.
May continue at 2 minutes. My lords.
As we are breaking in that volume 2D, at page 57, what is referred to is an alcohol committee.
Correct.
Would like to be informed what are the qualifications needed to be a member of the alcohol committee and whether
They were competent.
bar members, they have a, straight route to the alcohol committee.
Whether they were competent and eligible.
They are members of the bar.
The bar.
The bar, yes, sir.
Obviously be relatable to the industry.
Of course, that is
committee.
denatured. That is denatured committee, of course.